Okay, can you hear me? Okay, I hope all you can hear me. Some minor problem. After I use another way to start the lesson. So now I use a more proper way so to start the lesson. So first of all, can you hear the screen? This message from lecturer. Okay. If there's any problem, please let me know as quickly as possible. Good evening, everyone. I think all of you have arrived so early. I'm so surprised. First of all, I think response of student in last lesson was superb. Everyone was so eager to participate in the discussion. In this lesson, we'll cover Chapter 2. Chapter 2 is about classification of law. So how to classify the law, because we have so many legal rules. Just like a store, just like a shop, just like a supermarket, we have so many goods. We have to classify them. So law is also the same. I think Chapter 2 is a very short one. We only need one session to finish Chapter 2, and then we will start Chapter 3. We will cover half of Chapter 3, and so we will finish the remaining part of Chapter 3 in the next lesson. Chapter 3 is about sources of Hong Kong law. We have to know the sources of law. We have to know what is regarded as law, what is not regarded as law. For Chapter 1, it's only some introductory concept. Some students may have difficulty in understanding what is meant by legal person, legal capacity, legal status. Everything is about law. Okay, from now on, you have to be legalistic. You have to use a legal perspective. Do not just use some common sense. From time to time, we'll discuss with our friend on some legal issue like court hearing, or investigation, etc., etc. Most people will only use common sense. But as law student, you have to be more legalistic. Okay. Make sure that every lesson you have all the material, verbal or answerable, or you may prepare your answerable. And also unfinished lecture notes, for example, if we are not able to finish Chapter 3 in this lesson, so you have to bring the lecture notes of Chapter 3. Also, you remember the day for each lesson. Usually is Tuesday and also Thursday. I'm very happy to know that some students have sent me an email to ask me some question. It means that they are very enthusiastic about legal study. Usually I will tell you what the question. Of course, I will not disclose the identity of the student, but I will tell you the question and also my answer. I think other students may have the same query, but sometimes because of different reasons, they do not bother to send me email. But at least many students, I think many students will have the same question. For example, artificial person, it only means person made law naturally or artificially. So of course I use the example of company is the most well-known example of artificial person, but it's not the only one. There are so many examples. For example, say owners incorporated, 業主立案法團. Okay, it's also a very good example or artificial person. Even school, say university, is also artificial person. Okay? But usually in legal study, we will only tell you the example of company. The other one, the question of ultra-virus. I think some students they may have some concept about ultra-virus. In fact, ultra-virus, the doctrine of ultra-virus for company has been abolished, but it still has some implication. For company, company is still limited by its object, especially for some money-making body. For example, charitable organization, they still have object clause. Okay, even though now the object clause is optional for most company. Okay, you know more about ultra vires in company law. So if you study law in Module 4 company law, you will know more about the doctrine of ultra vires. Recording. Recording is quite useful. In the past, we did not have recording. For students who have missed the lesson, you can only refer to the lecture notes. But now you can refer to the recording. Many teachers will find recording is a quite unpopular idea. Many teachers don't like the idea that the lesson is recorded. Okay, because we are so afraid of any mistake we made in the lesson. But now the recording is something unavoidable. Even though we may have in-person class, the proper name is in-person class, not face-to-face class, right? So it's the proper name. Still there will be recording. I know in the future, even though we have in-person class, we still have recording, no matter whether we like it or not. So for our teacher, they have to accept the idea of recording. The recording. So as far as I was told by the EA, recording will be uploaded to SOAP within 3 days after the lesson. Of course, you have to be more considerate. Sometimes they have very heavy workload. They may not be able to upload the recording to SOAP immediately. So please look that. Usually they will do it within 3 days after the lesson. I think depending on the workload. So you may listen to the recording again. For some students who have missed the lesson, or some students who have problem in listening to the lesson, maybe there's some problem in Adobe. So I think it's a very good idea. And also another student asked me the number of national law, 全國性法律。So the national law, why we call it national law? So we know this idea in this lesson. Because national law is in contrast with regional law. National law is used throughout the whole of China. It's different from regional law. Because regional law is only applied to a certain area. For example, the local law of Shanghai is only applied in Shanghai. It does not apply in other places of China, right? But recently, so people that in the past it was only 12, right? But recently we have 2 more: national fact and also national security. 國旗法及港區國安法。So the total number is 14 instead of 12. A student told me even in the website of the LegCo, it is only 12, right? I think updating, of course, you have to know that law must be updated. Sometimes, even if you go to the website, the information may be a little bit outdated. Oh, sorry. Okay, now we go to chapter 2. Chapter 2 is about classifying law. We don't need so the whole lesson. We just need one session. Because it's a very short chapter. So classifying law. First of all, we have to know what's meant by classification, why we have to classify, and how to classify law. And also we will tell you the major division of law. Altogether, we have 6 most important classification. So we'll do some exercise to learn how to classify individual legal concepts. So fire the 2 different types of legal concepts. Please go to page 24. Please go to page 24 of the manual. Find the 2 different consequences. TV1. You own a car while you are stopped at traffic light. I come up to you and force you to get out of the car. I get in and drive the car away. The car is later sold to a stranger. what are the two different type of legal consequence that might arise on the given fact? Can you think of any possible types of legal consequence that may arise? Prison, criminal, theft. Very good. The example we just want to show you. We just want to illustrate the fact that for a single incident, okay, so there may be two possible legal consequences. The two major ones is civil and also criminal. I think most people will think of criminal. Right? I think most students, most people have better knowledge in criminal law. Right? First of all, criminal law. So the possible criminal charge may be robbery. Because that guy has used force. Whenever the bad guy has used force, usually we will use robbery, even though he's also stealing. But of course, robbery is a more serious act of stealing. So if the bad guy has used force in stealing, so usually it's called robbery, 搶劫, okay? So of course he's selling the car, etc. But it's already included in robbery. How about civil? Most people will forget civil law. So that apart from criminal law, we also have civil law. What is that was the most popular cause of action. So we call it intentional tort. You know more when you study, say, tort law. So we call it intentional tort. 故意侵權故意侵犯。So we have tort. Later on in Module 3, we will study tort law. So mainly speaking, tort law is divided into intentional tort and also negligent. So if you cause a tort intentionally, for example, you attack someone, you say damage other people's property. In civil law, it's called intentional tort. But if you do not do it intentionally, it's only negligent, right? So we just want to illustrate the fact. So for many incidents, it will have say two different types of legal consequence. Mainly is criminal law and also civil law. Of course, this concept is quite difficult to understand because most people only know criminal law. Not so many people will think about civil law, right? What is classification? It's very common sense, right? Classification means organizing individual items into distinct categories. Okay? For example, if you have so many friends, what do you have to do? You have to classify them. You have to classify them. This primary school, classmate, say secondary school classmate, and also friend you met, in company A, so your colleague in company B, your colleague in company C, etc., etc. So it is the way for you to classify your friend. Okay? But how about law? So you will see the classification. Okay? So for example, law is divided, is classified into so many subjects. We have criminal law, contract law, tort law, company law. Take tort law as an example. So under the heading of tort law, we have so many different subtopics. Right? Negligent, misstatement, negligent, defamation. It means that if you want to know the law about defamation, what should you do? You go to a textbook about tort law, okay? And then you go to the chapter on defamation. For example, it's in chapter 10. You go to chapter 10, defamation. You know all the law about defamation. After you have learned the law, you can determine whether the statement is defamation. Okay? For example, if someone say has used somewhere bad language about you, so for example, your friend, if someone tell you to go to hell, okay, is it defamation? You have to go to the textbook the chapter on defamation to determine. You have to understand the definition of defamation, and then you have to determine whether the statement amount to defamation. Okay, so it's the reason why we have to classify. Okay, now please go to page 25, or we do activity 2. Page 25. Purpose of this activity is to prompt discussion of what is involved in the process of classification. You see an advertisement. So we have so many different items in the ring-on store. So why is law like the ring-on store? What is the similarity between legal rules and the goods in ring-on store? You see so many items in ring-on store, perfume, household goods, clothes, bedding, toys, and lots more. So what is the similarity? Many departments classification of law. Very good. Both of them have to be classified. Okay? You have to classify the goods. Otherwise, you cannot find what you want. Okay? So if the goods are not classified, how can you find them? You need a lot of energy. You need to spend a lot of time, a lot of energy to find a bottle. So if goods are not classified, law is also the same. If law is not classified, it will be extremely difficult for you to find the law. So now law is classified. So defamation is under the heading, under topic of tort law. So you just go to tort law, and then you can find the law about defamation very easily because law is classified. So it's the function, is the use of classification. Very good. But how? What is classification? So of course, most people will use common sense. I think no need for anyone to teach you how to classify. Right? So how to classify your friend, how to classify the item in your home. I think it's something very common sense. But to put it more seriously, so the classification it means to group things together into family or category. But we have to find something in common. Okay? So when we group things together, for example, you group John, Mary, and Peter together. Why? Because all of them are your colleague in company A. You work in company A for 1 year. You know John and Mary, right? So you classify them because they are your colleague in company A. Okay? So the something in common is that all of them are your colleagues, the employee of company A. This is the reason why you group them together. It's something very common sense. Okay? So we call it attribute. Okay? We call it attribute. So they must have some common attribute. Okay? For example, we use this attribute to classify something into meat. So this one is food. This one is vegetable. So it's a process of differentiation. What's the value? So of course, it's very common sense. So for most people, they will say, "Oh, why you classify?" It's very simple. If you classify the goods or food into different categories, it will be much easier for the consumer to find what they want. So you want to find a chicken, you go to this section. The section is on meat. So you want to find an apple, you go to the section on food. You want to find a carrot. So you go to the section on vegetable. It is very easy for management. It's necessary for management. It will be much more convenient for us to find what we want. Okay? But in law, so of course, classification can help us to find the law. But it also enables us to see the general type of problem arising out of a particular situation. Okay? Because, say for those laws, they have the same type of problem. For contract, usually it's a problem, it's a dispute between the contracting party, for example, buyer and seller. From time to time, they have dispute, right? They have dispute on the quality, they have dispute on the quantity, they have dispute on the delivery time or the goods, etc. Right? So it's the general type of problem. Okay? Tort law. So for tort law, there's no contracting party, but it's some kind of civil wrong. Someone has done some civil wrong to another person and caused him some injury. So it's the reason why we have to use tort law. Criminal law is an offense against the society. Okay? So you have to define a concept by picking out its essential characteristic. Why so many things are grouped into contract law? Because they have the same attribute. Okay? So for those legal rules having the same attribute, it will be classified under the topic of tort law or criminal law. Okay? Usually they have the same attribute, okay? And also they have the general type of problem. And also by doing so, we can define a concept by picking out its essential characteristic. And also we can distinguish one concept from another. For example, what is the difference between contract law and tort law? Okay? No, to some extent they are similar. Okay? So both of them are some wrongs against the other party. But the difference is that for contract law, there must be contractual relationship. For tort law, you don't need any contractual relationship. So for tort law and criminal law, the difference is that tort law is only civil wrong. Okay? It's only a dispute between two persons. But for criminal law, it's a wrong against the society. It's not only dispute between two persons. Okay? By classification, you can understand the legal relations more clearly. So it's the function, it's the use of classification. So we use a very important concept called concept organizer. So the concept organizer is called NCE. N stands for name of the concept, C stands for characteristic attribute, E is the example. So that when you study law, some students they may have difficulty in understanding the legal principle. One of the reasons is that sometimes legal principle is a little bit abstract or conceptual. Usually in teaching law, we have to use some example to illustrate the legal concept or legal principle. After you know some example, like for example, artificial person, you do not know what is meant by artificial person. But I tell you, one of the typical example is company. Of course, you can understand the concept more easily. Because company is created by law. It's not born by the mom. Okay? So it's different from a natural person. It's made by law. It's made artificially. So everyone knows what's meant by company. So you can understand the concept more easily. So we have to use example. Otherwise, many students will find it difficult to understand. So bear in mind, remember this term NCE, name. Okay. Name, characteristic, and also example. Is NCE, name, characteristic, and also example, right? Collection of material fact. After you have collected some fact, from time to time, so when you are solving a problem, the first step is to collect fact, right? So you have to find out the fact, you have to ascertain the fact, and then you have to extract the essential ingredient. Sometimes we call it essential characteristic. Now please go to do the activity on page 28. Page 28 is a list of some of the features of a common law and also a civilian law legal system. So in the last lesson we have mentioned so the two major legal systems in the world is common law, originated from England and spread to all the colony and former colony of England, including US, Canada, Australia, etc., also including Hong Kong, also Malaysia, Singapore, etc. So the other one is civil law or civilian law legal system. Mainly it was originated from European countries like France, Germany, etc. It was spread to all countries in Europe, and then some Asian countries, including China, and also Japan, etc., etc. Okay. Now please go to page 28. And do the exercise on page 28. So you are not supposed to know the answer, but just guess. This doesn't matter. Okay. So I think instead of just telling you, please do the answer before I tell you the. Please do the exercise before I tell you the answer. So there is a list of some of the features of the common law system and also the civil legal system. From now we have A to I. File which one? So the name is common law and also civil law. Okay? And then you find the characteristic. What's the most important characteristic of common law system? What's the most important characteristic of the civil legal system? Try to find out which one, and then give some example. Others are only example to illustrate the characteristic. Just choose. So A, just choose whether decide whether it's common law or civil law. Okay? B, whether it's common law or civil law. C, whether it's common law or civil law. Okay? You may write down your answer on your lecture notes. So I'll give you 3 minutes time. Many students will find it difficult to find the answer. Please note that There's no need for you to memorize the answer of this part because we won't say any question. To compare and contrast the two legal systems. So it's not what we are going to cover. We have to illustrate the difference so that you can understand the common law system more easily. Sometimes one way to understand something is to use another concept to compare and contrast. So by comparison and also contrast, you can understand the concept more easily. The first one is common law. So common law is the name. The first legal system is common law system. Common law is the name. What is the defining characteristic? The most important defining characteristic. So that we only have one. So it's A. Case law is an independent source of law. You may not quite understand what's meant by case law. To put it simple, case law means the legal principle is inside the case. Okay. So for case, we have judgment. The document. So for a case is called judgment. After a case is being heard, so usually the judge will make the ruling. Okay. The judge will make the decision. For example, the decision is that the defendant is found guilty, is put sentenced to 3 years of imprisonment. It's the outcome of the case, the decision, but more important thing is the reasoning. Okay? Why the defendant was found guilty, why he was sentenced to 3 years of imprisonment, it will be explained in a document called judgment, 判詞. Okay? When we study a case, usually for the full case, in fact it means judgment. Judgment sometimes may be very long, so maybe more than 100 pages. Some are very short, maybe only just a few pages. Okay? Later on I will give you some sample judgment, so you can go through it and try to understand the contents of the judgment. Right? So it's an independent source of law. So case law, the case, they are already law. Okay? They are not only for reference, they are simply law. Okay? So it's why it's called case law. So for civil law, the most important characteristic is B. Judge apply the law found in a code. A code is a big law book, 法典. Okay? Of course, it's a very big law book. So in civil law system, usually they have two major code. Right? So it's the civil code and also criminal code. Okay? All the civil law are found in the civil code. All the criminal law are found in the criminal code. Okay? You can find the law more easily. For civil law, there's no case law. Case is only for reference. It's not law. Okay? Then we go through the remaining item one by one. So C. Do you think common law or legal system? Common law or civil law? In fact, it's common law. C is common law. Judges are appointed from the legal profession. It means that all the judges, they have been lawyer. They have been practicing lawyer for a certain period of time. The shorter ones is magistrate. Even for magistrate, the most junior judge in Hong Kong, they must have at least 5 years of experience as lawyer. Okay? So there must be at least 5 years. Okay? It's already the minimum for magistrate. So it means that all the judges, they have been lawyer. Okay? So you cannot graduate from the law school and become a judge. It's not possible in Hong Kong. Okay? It's not possible in the common law system. Okay? D is the example of civil law. Judges are trained in a national school for judges. 國家法官學院. Okay? So for European country, they have a national school for judges. For the graduate, they will become judge. They start as a junior judge and then promoted to be senior judge. They have never been lawyer. Okay? So it's the major difference. E. Adversarial is also a characteristic of common law system. Adversarial means confrontational, debating. 對抗式. It means that the lawyer on both sides just like debater in a debating competition. We have in the debating, we have government side, opposition side. For the court hearing, we have the prosecutor and also defense counsel, or lawyer acting for the plaintiff, lawyer acting for the defendant. They are in an adversarial process. F is for civil law, inquisitorial. It means that the judge will conduct the trial. Most of the questions are asked by the judge in a civil law system. But in common law system, most of the questions are asked by lawyer instead of the judge. The judge seldom interfere. Okay? The judge seldom asks any question. Okay? So judges in general are bound by previous decision. This is also common law. So we call it the doctrine of binding precedent. A precedent is case in the past. For example, a case in 1970, a case in 1980. We call it a precedent. Okay? Usually the judge in the common law system will follow the precedent. So we call it the doctrine of binding precedent. H. Judges are not formally bound by past decision. This is the characteristic of civil law. For civil law, judges are not bound by past decision. They can refer to the past decision, but they are not bound by them. They can choose whether to follow or not to follow. Individuals are protected against abuse of power by the state through judicial review proceeding in the court. It's also a very important characteristic of the common law system. So I is also for common law. Of course, you are not required to know the difference between common law and civil law legal system, but it's something quite elementary. So after you have learned the difference, you can understand the common law system more easily. Classifying major source of major division of law. So in fact, so when we classify something, usually we will use one attribute, one way to classify something. Just like your friend, you classify. According to where you met those people, you met those people in primary school, you met them. Those people in secondary school, you met them in company A, in company B, and company C. It's the usual way to classify your friend. Okay? But there are some other way to classify your friend. For example, you can classify your friend according to the race, color, nationality, height, weight, educational level, age, sex, etc. But it's not something so common. It's not something so usual. Right? We just want to tell you we have more than one classification. Don't think that we only have one way to classify the goods, one way to classify the law. Okay? So of course, for example, in a department store may classify the goods according to the price. Okay? For example, for goods, so you may go to some counter, all the goods are say a lot more than $10. So you can go to find lots of goods. They are not so well classified, but all of them have the same characteristic. Is that the price is not exceeding $10. Okay, so it's also one way to classify the goods according to the price instead of the other criteria. So it depends on different criteria. If you use different criteria, you will have different classification. And also, traditionally, I will contrast two pair of legal category. Okay? Just like the case, for example, if you want to point out someone is, you have a friend who is very tall. How can you illustrate? How can you tell other people that he's very tall? The one effective way is to compare your friend with other people who is not so tall. Okay? For example, your friend is 200 cm, okay? 200 cm tall. You classify, you ask him to stand next to a person of only 160 cm. So you see a big difference. Okay? So it's the usual way for us to illustrate so the characteristic of certain person. So we can have 6 classifications. These are the most usual way to classify the law. Okay? So altogether we have 6 classifications. We use different attributes. We can have different classification. Okay? We can go through them one by one. Please note that the detail can be found in the manual. So you can go to the manual. You can find the detail. Okay, so you can find the detail on page 29. Okay, so the first classification is international law versus municipal law. Okay, so for international law, is law used among countries. Okay, we know that for example, Hong Kong law is only municipal law. It's only used inside China. Okay, it's only used in Hong Kong. But public international law, so international law is used among countries. So it's the difference between municipal law and international law. International law 國際法, municipal law 國內法. Municipal law is only used within a country. International law is law used among countries. So because international law is unavoidable. When we have international trade, we have communication, aviation, so many things. So many things are conducted among different countries. This is the reason why we must have international law. You cannot just have municipal law. There must be international law. For example, the contract is between a company in Hong Kong and a company in Japan. You cannot just use Hong Kong law. It must be governed by international law. Public law and also private law. The second classification is public law and private law. For public law is relationship of legal person to each other in the public sphere. Okay, for example, government. So election is public law. So for contract law, tort law is private law because it only involves private person. Okay. And third one is criminal law and civil law. So for criminal law is relationship of person to the state. Okay, is some wrong against the society. For example, robbery, murder. It's not only wrong against the victim. Okay, so not only the victim is concerned. The whole society is being is being hurt. Okay, so it's a wrong against the society. It's the reason. It must be criminal law. Okay, for civil law usually it's only dispute between two different persons. So we have contract law, tort law, property law. They're only example of civil law. And also, if there's any dispute, the hearing, the proceeding is called civil proceeding. 民事訴訟. But for criminal law, there will be criminal proceeding because it's a wrong against the society. Later on, you see the big difference. There's so many different procedure are different. Sometimes judges are also different. The evidence law, the procedure, the consequence, so many things are different for between criminal law and also civil law. So we go to the number 4, substantive law and procedural law. So in the last lesson, we have already explained the difference between substantive law and procedural law. Procedural law, because we have mentioned before, procedure is something very common sense. We have a lot of procedure in so many things. In our daily life, applying a credit card, applying a library card, or applying for a personal loan, you have to go through the procedure. There must be procedure for so many things, but usually the procedure are very simple. So you only have to take a few steps before you can get the credit card. You only need to take a few steps before you can get the library card. The procedure are very simple. No need to use law to explain the procedure. But in court proceeding, the procedure are very complicated. Why? We have mentioned before. One of the reasons is that the judge does not want so many people to conduct legal proceeding. So if the procedure are very simple, many people will sue the other people very easily. But if the procedure are very complicated, so many people will be discouraged. And also, you cannot do the job by yourself. You have to find a lawyer. The lawyer, they are expert on procedure. Okay, they are very familiar with the procedure. So you need to find a lawyer to do the job for you. So of course, by doing so, you are discouraged from taking legal action. Okay, but substantive law is only the duty and rights of legal person. So if you study contract law, you only know the rights of the contracting party, but if you want to take a legal action, you need procedural law. You need to know the civil procedure before you can conduct the legal proceeding. Legislation and case law. Legislation usually we call it ordinance. For example, the crime ordinance, company ordinance, they are a very good example of legislation. Legislation are those law passed by the legislature. In Hong Kong, it's the Legislative Council. For case law, they are the legal principle inside a case. So it's called case law. In fact, they are made by the judge. Sometimes some people call them to be judge-made law. But case law is made by judge instead of the legislator. The last one is called law versus equity. This one is quite complicated. I think we have to leave it to chapter 3. At this stage, you may find it difficult to understand the difference between law and equity. So in chapter 3, we will trace the historical development of common law and also equity. You know the reason why we have the development of equity, what are the defects of common law. So by doing so, you can understand more easily the difference between say common law and also equity. In fact, in this level we use the term law. In fact, it means common law. So these are the 6 classifications. Please note that we are using different attributes. Why we have 6 different division of law? Because we used 6 different say classifications. Okay. So I think one of the important one is substantive law versus procedural law. Please note that. So when you study contract law, when you study tort law, you only know the substantive law. Okay. So if you want to take an action, you have to know the civil procedure. So in this program, we have 2 modules on procedure. The first one is civil procedure. There's module 2 of CLS. And then we'll, in the second year, we will have criminal law and procedure. Procedure are very complicated, much more complicated than you can expect. Nowadays, in the society, everything is as simple as possible. All the banks, they have to make the procedure for applying a credit card to be as simple as possible. Okay? Sometimes you cannot even have to turn up in the bank, so you can get a credit card very easily. Because if the procedure are very complicated, many people will be discouraged from applying for a credit card. So I think only the court can use a quite complicated procedure. For most other people, they have to make it very user-friendly because they want to attract more people to use their service. To use the product, right? Even the government will make the procedure as simple as possible, so that they can save a lot of energy, they can save a lot of effort, and also they can save a lot of money. But the court is still very stubborn. The courts will still make the procedure very complicated. Okay? And also, when we classify individual legal concepts, instead of asking some general question, we have to ask more specific question. We have to point out the legal dispute, the legal issue. Okay? So we have to use more legalistic language. For example, we will, for example, if someone has done something wrong, usually we will ask, has the defendant committed the offense of burglary, the offense of robbery, the offense of murder, manslaughter, etc. is the language used by the lawyer. So the lawyer will not just say, oh no, has the defendant killed the victim? So it's not the language we use. So B is be under any obligation. So from time to time, especially in civil law, we have to know the concept of obligation. So obligation usually is in the legal sense. It means legal obligation. Usually we are not talking about moral obligation. Because it's not a concept. Okay? Because different people will have different moral standard. But law, we have the same standard. Any question? Tong Chut Yin? Legal duty. I think it's more or less the same. Legal duty and legal obligation is more or less the same. Also, judicial review. Judicial review will be mentioned in very briefly in chapter 7, in the chapter about about court. So in chapter 7 we will talk about the court system. Civil law, I think JR means judicial review. Okay? So we will mention judicial review in chapter 7, but mainly it will be covered in the module of basic law. Or C, the plaintiff own the car, so no, it's the legal language we will use. Now we go to do another activity. So for offenses, we know that in criminal law we have so many criminal offenses. 刑事罪行 so usually they are listed. Some offenses are listed in the FAB ordinance. So some are listed in the offense against person ordinance. Some are listed in the summary offenses ordinance. We have several ordinances, mainly containing many major offenses in Hong Kong. So now we do activity 4 on page 35 to 36. It's about theft and also robbery. Please go to page 35. Activity 4, understanding legal criteria, distinguishing theft and robbery. So the purpose of this exercise is to learn how to compare and contrast two different legal concepts. So the first one is section 2 of the FAB ordinance, which is something we have mentioned before. Is the definition of theft. A person commits theft if he dishonestly appropriates property belonging to another with the intention of permanently depriving the other of it. So it's section 2. Section 9 is the definition. Section 9 is the punishment for theft. A person who commits theft shall be guilty of an offense and shall be liable on conviction on indictment to imprisonment for 10 years. It means that the maximum punishment will be 10 years imprisonment. People that usually in Hong Kong, we only have maximum penalty, but usually we don't have any minimum penalty. Okay? So the maximum is 10 years. Okay? So if a person is prosecuted for theft, even though it's very serious, but the maximum penalty is only 10 years imprisonment. The judge cannot impose, cannot send him to the prison for 20 years. It's not possible because the maximum penalty is only 10 years imprisonment. Section 10 is the definition of robbery. Right? So subsection 1 is the definition of robbery. A person commits robbery if he steals and immediately before at the time of doing so, and in order to do so, he uses force on any person or seek to put any person in fear of being then and there subject to. So it's the definition of theft under section 10, subsection 1. Subsection 2 is about the punishment. The punishment will be life imprisonment. You can see the punishment for robbery will be more serious than theft. Okay? So it will be life imprisonment. So the job is to list out the similarity and differences between theft and robbery. What are the similarity between these two offenses? What are the differences between these two offenses? please, I give you 5 minutes time. Please go through these 3 sections and find out the difference between the 2 different criminal offenses. They are similar. There must be some similarity, but there's also different. Okay, just like the case when you compare 2 companies, you can find that they are similar in some aspect, but they are also different in some aspect. Just like 2 hotels, there must be some similarity. There are also differences. Now we may come to see the similarity and also difference between these two criminal offenses, theft and also robbery. So you see, in fact, they are similar. What are the similarity? The similarity both are involving stealing. Okay. So we can use the language of statistics. Theft, is the scope is smaller than robbery. So to put it simple, we can just say that robbery is theft plus use of force. Okay? So the difference is use of force. If the bad guy does not use any force, it's only theft. For example, pickpocketing. So if someone go to the shop and steal a can of food, it's only theft. Okay. But if he use force, for example, if someone is snatching a lady's handbag, is robbery, okay? Because he has used force in the stealing, okay? So is when in section 2 we use dishonest appropriation. In fact, it means stealing, okay? So the similarity is stealing, but the difference is for robbery. So the defendant has used force. For theft, the defendant has not used any force. Okay? Of course, so sometimes why, for example, why the wording he used for or put or sit to put any person in fear of then and they're subjected to force. Of course, in law you have to elaborate the concept. So we have to include as many things as possible. Otherwise, there will be loophole. Okay. So for some people, he has not exactly used force. He just threatened other people. For example, if you produce a knife to threaten other people, you put someone so in fear of being subjected to force. It's already robbery. Okay? There's no need for the bad guy to have exactly used force. Otherwise, so many people will not be found guilty. This is the reason why we have to make the definition. Sometimes we have to make it quite detailed, quite clear, and also quite long, because we have to want to cover so many things. Okay? Otherwise, there will be loophole. The loophole can be used by those people, and they will be found not guilty if our law is too simple. So it's what we have mentioned before in chapter 1. We have mentioned before in a legal rule we have legal condition and also legal consequence. So subsection 2 is the legal consequence. So imprisonment for life. This one is the legal condition. So usually legal condition is very long because we have to define the criminal offense very clearly. Okay? So it's the reason why we use very long language, very long sentence to define a criminal offense. Also, we use another example, contract and tort. For contract, it's a voluntary exchange or mutual undertaking. For example, if you have buyer and also a seller, the seller undertake to deliver the goods to the buyer. The buyer will undertake to give the money to the seller. Okay? So for both the seller and buyer, they have exchanged the undertaking to each other. So it's a contract. Okay? For tort, so that usually there's no agreement, no exchange of undertaking. The breach of duty, it means the breach of duty primarily fixed by the law and owed to person genuinely. For contract, you only owe your duty to another contracting party. Okay? For example, if your contract is only between two persons, A and B, A will owe a duty to B, B will owe a duty to A. Usually A will not owe any duty to any other person, so he will not owe duty to anyone who is not a party to the contract. But for tort law, he owes the duty to a person genuinely. For example, if you are the manufacturer of food, you owe the duty to so many people. You do not know who will buy the food. You will never know who will consume the food. Okay? So you owe the duty to a person genuinely. So the duty is fixed by the law. the duty is not fixed by contract, but in contract law, the duty is fixed by the contract. The quality, the quantity, the color, the delivery day, the package. So many things are governed by the contract. The party can change so many things. They can agree on so many things by themselves. But for tort law, the duty is fixed by the law. Okay, it's not fixed by the party. Please go to page 37 and do activity 5. We have 4 different fact patterns. Trying to determine whether they are contract or tort. Using the definition of contract and also tort, and so you have to determine whether each fact pattern is tort or contract. I think this activity is quite easy. So I only give you 3 minutes time. Okay? Now we can go through them one by one. So number 1, Wong placed an order for 10,000 mobile phone, and so he offered to pay 400 each for $400 for each phone. Telecom accepted arranged for the phone to be delivered to Wong's shop. Okay. So is it contract or tort? Number 1. I think it should be contract. Please for number 1, it should be contract. Sales of good. Sale of good is a specific contract. Okay? So it's something very usual in our daily life. Whenever we go to the supermarket, whenever we go to the shop, so we have a contract with the seller. To put it more specific, we call it sale of goods. In fact, it's also some kind of contract. Okay? And in fact, it's the most usual contract in the society. Okay? So it should be contract because it's a mutual exchange. So this is exchange of mutual undertaking. So Wong is the buyer. He undertakes to pay the money to the seller, telecom. Telecom is the seller. Telecom undertake to deliver the phone to Wong's shop. Okay? So it's an exchange of mutual undertaking between Wong and telecom. So it should be contract. Number two, a son was killed after being hit by a lorry while crossing Kowloon Park Drive. Accident occurred around 5 p.m. when the driver of the lorry Chen pulled out to overtake a slower vehicle. Okay? For this accident, is it contract or tort? Number two. Very good. It should be tort. Because it's an accident, we cannot see any agreement between any two parties. Usually in an accident, the wrongdoer usually is the driver. He simply does not know the victim. Okay? They do not know each other. Of course, sometimes in some cases they may know each other. But for most of the accident, the wrongdoer simply do not know the victim. Okay? There should not be any agreement. Okay? There's no exchange of mutual undertaking. So it's only breach of duty fixed by law. The law has fixed the duty for the driver. Okay? And also the duty is owed to everyone. Anyone may be the victim. No one knows. Okay? The driver will not know who will be the victim when he is careless. Okay? Number three, P&D laboring owner. So when while renovation were being carried out on these premises, a wall collapsed, causing serious damage to P's property. D agreed to repair the wall. The work took 2 months. During this time, P and his family suffered chest infection from the dust caused by the building works. Is it tort or contract? Another thing. It's also mainly tort. So because in the accident, the wall collapse causing damage. So it should also be a tort case. But when minor part may be a contract. When D agreed to repair the wall, it may be a contract between D and P. Right? So number 4. But mainly is tort. Number 4, Chen has told Hope that she will pay her $4,000 per month if she will work for her as a domestic helper. So it's an employment agreement. Okay? Is it tort or contract? Very good. So it should be contract. So it's an employment contract, employment agreement. Okay? So it's also some kind of contract. So the answer should be C, contract. So we have minor part like property, we have personal property and also real property. So property is divided into personal property. For example, our computer, the car is personal property. Real property is land, your flat, your apartment, your house, your land, the land. So it's real property. So we can do some revision. Classification is a process of differentiation. We have to differentiate. Okay? We have to find out the difference between two concepts. So we call it differentiation. So major division, we have international law versus municipal law, public law versus private law, criminal law versus civil law, substantive law versus procedural law. Please know that substantive law is a term we are not familiar with. Not so many people know what's meant by substantive law. But when we have procedure, so we can understand the concept more easily. Legislation versus decisional law. Decisional law sometimes is also called case law. Common law versus equity, it will be explained in chapter 3. Number 1, contract must be voluntarily exchange of goods between two parties. Of course, it's false. So it's not only confined to exchange of goods. It's not only sales of goods. Nowadays, we have so many different types of contract. Some contract are related to service. Service sometimes may be more important than goods. Number two, NCE is a powerful tool for calculating about. So it's true. If the calculation define concept by picking out all its characteristic. The answer is also true. Number four, law is like the goods of ring on store. It can be classified into different categories, so it should be true. We can classify law by asking whatsoever question, so it's not so true. It should be false, right? We have to ask some relevant question. What's the difference between robbery and theft? It should be use or false. Which pair of division of law is incorrect? So it should be A. Common law and criminal law. They are not. It's not a proper comparison. Right? Okay, I think we can now take a break. Please take a break for 10 minutes, and then we'll go to chapter 3. So we'll learn the sources of law in Hong Kong. Okay. Okay, so let me try. I don't know whether it worked or not. Okay, in the for the last lesson, I forgot to record the lesson starting from chapter 3. So I forgot to record the lesson on the second session, which should be part 1 of chapter 3. And now I try to record the lesson. Okay, so I don't know whether it worked or not. Okay. But I know I just try, right? So so the video does not work, so you cannot see me. First of all, so it's chapter 3, sources of Hong Kong law. So the outline is I will mention the PLC Constitution and other national law, and then the basic law. So the sources of law of Hong Kong so is in accordance with the Hong Kong Basic Law. So we have to know what is the provision under the Hong Kong Basic Law, and then the Hong Kong Bill of Rights Ordinance. And so for the two major sources of law, so we have the legislation and also the common law. So for the first part, I will only give any very introductory concept about common law, and then we'll go into details in the third lesson. So the common law is composed of the common law itself and also the equity. So I think this part is particularly difficult. So we need a lot of energy to explain the development of common law and also equity. So that you can understand the difference between common law and equity. And also we have some minor sources of law like the customary law. And also you have to know what is the impact of international law on the law of Hong Kong. So in chapter 1 we have the general introduction, and then now chapter 2 you have just finished chapter 2. So chapter 2 is about classification of law. So The most common classification is 6. Okay, so we have 6 common classification of law. So we know criminal law, civil law, and also civil law versus common law, case law versus statute law, etc., etc. Now you have a better understanding about law. Don't think that we only have one classification, but in fact, we have more than one classification. It means that law can be classified into so many ways. Now we have to find the law. So in chapter 3, we have to recognize, we have to understand what are the sources of law. What are we gathered as law by the basic law. In the next chapter, we have to learn how to find the sources of law. Chapter 5 and chapter 6 are the 2 major sources of law. So in chapter 5, we will learn the meaning of case law. We'll use an example, a judgment. To understand the case law, we have to learn how to extract the legal principle from the case law. And also, we will study the doctrine of precedent. So many students will ask the same question. There are so many cases. Which one should we should we follow? Okay, when we say we follow the case in the past, but there are simply so many cases. How should we follow the cases? We have to know we have to understand the doctrine of precedent. There's a set of rule, so that we will know which cases we will follow, which cases we don't have to follow. And chapter 6 is about legislation. Basically, so we will learn how to the legislation is passed by the legislature. What's the process of legislation? And then a more important topic is about interpretation of legislation. How the legislation can be interpreted. So for basic law, we can find the meaning of basic law on page 39 to 40 of the workbook. Altogether, we have 4 different meanings. For many terms, it has more than one meaning. So you have to identify the meaning you are talking about. The first one is an origin. The origin of the law usually means the historical origin, the historical background. Everyone know that the Hong Kong law is based on English law. Okay, in fact, most of the cases are from England, and also most of the legislation in Hong Kong are simply based on the English equivalent. For example, the Sales of Goods Ordinance is simply the same as the Sales of Goods Act. The Company Ordinance is based on the Company Act. So at the very beginning, we simply copy the legislation in UK with very minimal, amendment or adjustment. Okay? But of course, now we may develop quite different ordinance. We'll refer to different places, different jurisdictions when we are making our law. The second one is called foundation or basis. It means influences trigger legal change. It's also called formal sources. For example, the thinking of equality may lead to anti-discrimination legislation. I think it's something less philosophical or conceptual, so we won't talk too much about this meaning, right? It's something about ideology. For example, the ideology of equality, the ideology of fairness, etc. Right? It will affect the development of law. Number 3 and number 4 is what we are talking about for this in this module. For number 3, it's about literary sources of law. It means where we can find the law. So it's the written and electronic record of the law. So it's by legal research. For example, in the past we have the hard copy. The legislation is called statute book. The case law is is called a law report. Usually you have to go to the library, the law library, because most of the ordinary library, they don't have this kind of book. So you have to go to the law library before you can find the statute book or the law report. But number 4 is the legal sources. Is the focus of this chapter. It means what are regarded as law. So you have to identify what are regarded as law, what are not regarded as law. Mainly we have cases and also legislation. Altogether, we have two formats of legal sources. Some are in the format of primary legal source, like case law and legislation. The other one is a secondary legal source. They're simply commentary and also textbook. For the secondary legal source, sometimes they may not be so reliable, but they are more systematic, easier to understand. Okay? So it's the reason why most of the law students they have to rely on secondary legal source instead of the primary legal source. But for the law teacher, they always ask or they always request the law student to refer to the primary legal source, which is more authentic, more reliable. So for the sources of law, we have to talk about the Constitution of China. So in China, we have the 1982 Constitution. Because why sometimes we have to specify is 1982. Because say before that, so China have several constitutions. Okay? But of course, so now if we talk about the Constitution, usually it will simply means the 1982 Constitution because it's the most updated one and also it's the most relevant one. For the previous Constitution, I think they are not so relevant. So not so many people will talk about the Constitution in the past, except some legal scholar. So it's the highest law in China. So Article 31 of the Constitution provides for the establishment of a special administrative region. So altogether we have two special administrative regions, Hong Kong and also Macau. Okay? So for the law used in China, is classified into national law and also regional law. National law is used throughout China. So for example, the criminal law, the civil law. But for for regional law, they're only used in some region. For example, some law about which is only used in Shanghai is only a regional law, it's not national law. All the national law in China will be applied in Hong Kong. Only those listed in the Hong Kong Basic Law NSV by the National People's Congress Standing Committee will be applied in Hong Kong. Currently, the number is 14. If you go to some students mentioned that when they visit the website of the Legislative Council, they mentioned that the number is 12. So the number was correct recently. So maybe in 1 year before, the number was correct. But no, in recent year, we have two more. Two new one is the national flag and also the national security. The one on national security. Okay? So we have so many examples. For example, laws on the national flag and national emblem, nationality law, etc. The new one is the national flag, 國旗法, and also we have the law of on safeguarding national security in Hong Kong. 港區國安法. Okay, these are the two new national law which are applied in Hong Kong. So that the total number is 14 instead of 12. If you want to find the Constitution of China and also the Basic Law, you can simply go to the website e-legislation. You go to the index entry and you click enter. You click others. A1 is the Constitution of China. And also this one, A2 from A7 is the amendment. These are the amendment to the Constitution. So A101 is the Basic Law. So if you click the Basic Law, you can find the Annex 3. This is the Annex 3. Okay? It lists out all the national law applied in Hong Kong. The Basic Law is important. It's so important that it's a separate subject in our program. So it's Hong Kong's written constitutional document. Before 1997, we also have some constitutional document like the War Instruction, Letters Patent, etc. So colonial regulation. These are, but not so many people knew those constitutional documents. Except those students who study EPA, Economic and Public Affairs, may have heard of this document. Other most ordinary people, they did not know what is meant by royal instruction, letters, patent. Right? They have never heard of those terms. But in Hong Kong, at least most people know basic law, even though they may not be very familiar with the content. But at least most people have heard of the term basic law. Now please go to page 42 of the manual. Page 42. With reference to the major division of law explained in Chapter 2, is the basic law international or municipal law? International law is the law used among different countries. So municipal law is only law used inside a country. Of course, the answer should be municipal. Basic law is only used in China. It's not used in other countries, so it's only a municipal law. 國內法. Supremacy. The most important significance of the basic law is that it's supreme over other legal sources. According to Article 11, Paragraph 2, no law enacted by the legislature of the Hong Kong SAR shall contravene this law. Please note that we use the term legislature. It's a general term. A different country will have different legislature. Legislature is the body that makes enact the law. So you have to submit the draft legislation to the legislature for approval. Right? In other places like Taiwan, they have the legislative yuan. So in China, in mainland China, is the National People's Congress and also the local People's Congress in different regions. Some legislation have been invalidated under this article since 1997. Even though the number is very small, but still, we have some legislation which have been invalidated under this article. Right? Invalidated means declared to be invalid. 宣告無效. Article 18, Paragraph 1 of the Basic Law provides that the laws of Hong Kong include the Basic Law itself. B is the law before 1997. The laws previously involved. Previously means before 1997. In fact, most of the laws before 1997 continue to be enforced after the handover. Right? So the laws previously enforced in Hong Kong as provided for in Article 8 of the Hong Kong Basic Law, including the common law, rules of equity, ordinance, subordinate legislation, and customary law, except for any that contravene the Basic Law. This one is very, very small in percentage. It may be more than 0.1%. We cannot see too many examples of law that has contravened the Basic Law, except some wording. For example, some wording like the Queen, colony, etc. So, of course, they will be amended. For those wording, they will be amended because so it's of some colonial color. 殖民地色彩. So laws and C is law enacted by the legislature of the region. It means law enacted by the Legislative Council after 1997. Every year we'll have new legislation, but the number is not too big when compared with the old legislation. The meaning of common law. For common law, please note that so it's a very difficult term. We need a lot of explanation for this part. Okay. First of all, for sources of law, we have to mention this, this part. Sources of law. Take an analogy. So we can say that sources of law is just like your sources of income. So what are your sources of income? For some people, the only source of income is the salary. They have a full-time job. The only source of income is the salary. They have no investment, no saving, no other source of income. The salary is the only source of income. But for some people, they have many sources. For example, for a businessman, he may also, for some people, they may have a full-time job or part-time job, so he have a salary from the full-time job, salary from several part-time jobs, and also he can enjoy dividend if he had investment in share. So usually this company will declare dividend to all the shareholder. The shareholder will get dividend from the company. Usually two times a year. And also they can get profit from investment. For example, he buy the share at the price of $2, and then he sell the share at the price of $4. He will get a profit of $2 per share. So is his profit. And also he can get the profit from business. If he operate a business, he will get profit from the business. So for some people, they have so many sources of income. Sources of law is also the same. In some country, the sources of law is very simple. So they only all the law are in a big law book or two law book, like the criminal code or civil code. You can find all the law very easily from either book. But in our common law system, the sources of law are more complicated. We have different sources of law. So we do not only have legislation, but we also have case law. So for common law, so we have four different meanings. Just like sources, we also have the term common law also have altogether four meanings. The first one is law applying to the whole of England. So it is something in contrast with local law. First of all, you have to know for England, it has so many kingdoms. It has so many kingdoms before the year 1066. So you can find so some map will say that England was divided into so many kingdoms. When England has so many kingdoms, just like China has so many kingdoms. So before the Qin dynasty. So what will happen if a country has so many kingdoms? Usually different kingdom will use different law. They may even have different language, different custom, different currency, different measurement. Most people, they will not go to other kingdom. They will just stay in their own village. So for the whole life. So it will not cause a big problem. But when the country was united, when the country was unified, so there will be a lot of communication among different places of the country. So is it desirable for them to use different law? Okay. Of course, it was highly undesirable. Please look at we'll try to illustrate the development. In China, we have a very famous emperor called Qin Shi Huang. He was the first emperor of the Qin dynasty. Before Qin Shi Huang united China, different kingdoms use different law. The question is it desirable for different part of the country use different law? Of course, the answer is no. The answer must be low. It's highly undesirable if different kingdoms use different law. What did Qin Shi Huang do when he wanted the whole China to use the same set of law? The answer is very simple. He made new law and asked all people to follow the new law. Will you be happy if the government asks you to use completely new law? Just like the case. So if the government asks you to use completely new law, of course, most people will feel unhappy. But what happened to the people if they refuse to follow the law of Qin Shi Huang? The answer is also very simple. They will be killed. They will be punished, right? But how about William the Conqueror? What did William the Conqueror do? Did he do the same as Qin Shi Huang? Of course, you cannot expect the English king to be so powerful. He was not so powerful as the Emperor of China. What did he do? So because there were so many parts, he just extracted the law common to all parts of England. Okay? So no, he just tried to find out what are the laws which are applied in all parts of England. So of course, by common sense, you can find out some laws are applied. Some laws are common to different parts of England. For example, if it's illegal for you to kill someone, it's very illegal for you to steal other people's property. Okay? It's something everyone agree. No one will disagree. Okay? No one will say it's proper. You can take away the property of other people as you wish. So it's not something possible. I can kill some other people. It's not possible. You cannot find any place to allow someone to kill another person. Okay? So it's the law common to all parts of England. So William the Conqueror extracted those laws. So it's the reason why it's called common law, because it's common to all parts of England. The common law was not by promulgation. He did not write down the common law on a law book and promulgate the law to everyone. The common law was only spread to the whole country by the common law court from the 12th century. Because when everyone realized that the court will use the common law, what would they do? They will just follow the common law. If you do not follow the common law, you will suffer. You will incur loss. Okay? You will lose your money. Okay? So it's the reason why all people will follow common law, and also they do not find common law objectionable, because common law was something used by all people, okay, in England. So this is the reason why no one would like to object the common law. So it's the original meaning of common law. So when William the Conqueror unified England in 1066, he extracted the law common to the whole country. It's the reason why it's called common law. Number two, the second meaning of common law is law based on cases rather than on code. So later on, you can find, we can give you an example. When the court is hearing a case, so the court will make a decision. For example, in a criminal case, the case is by appeal by the Mr. Yun Shek-on. He appealed to the court on his conviction. At the end of the day, the court after the hearing will make a decision. For example, in this appeal, so the court held that the appeal against sentence is accordingly dismissed. Okay, so the appeal is not allowed. So it's the final decision. But when the court dismissed the appeal, what did the court have to do? The court have to explain the reason in a document called judgment, 判詞. Okay. So in the website of the judiciary, you can always find some cases or judgment. Okay. So by reading the judgment, you can find out the reason for the decision by the court. The court has to explain its decision in this document. So for law students, for lawyers, they can always go through the document and find out the law. We can extract the law, the legal principle, the legal rules from the judgment. The law is inside the judgment. Is the reason why it's called case law. So it's very different from legislation. Because for legislation, for example, you can go to, you can always go to, say, chapter 1. So chapter 1 is called Interpretation and General Clauses Ordinance. So all the legal principles, the legal rules are listed in the ordinance section by section. You can find a lot of rules. For example, Section 5. Section 5 says that where any verb or expression is defined in any ordinance, such definition shall extend to the grammatical variation and cognate expression of such verb or expression. So it means that so it lays down a rule relating to grammatical variation. So if you use present tense, it will also include past tense, past participle, present participle, etc., etc. Okay. So it will resolve the ambiguity. The rule is listed in the legislation very clearly. But for case law, you have to extract the legal principle from the case. You cannot just like legislation, the law is not listed in the legislation one by one. Instead, the lawyer, they have to extract the legal principle from the case. Okay? So this kind of law is called common law. Okay? Even in the common law, so it's something in contrast with the civil law. For the civil law, the law is based on code. Or usually they have two law code. So it's the criminal code in 法典 and also the civil code 民法典. All the criminal law are in the criminal code. All the civil law are in the civil code. Okay? You want to find law relating to contract, you go to the civil code. You go to the relevant part of contract, and then you can find the relevant law. But for say common law, so it's not something so organized. So the laws are found in different cases, of course. So you cannot just go through the case one by one. So the textbook will tell you something more systematically. So you have to study law, you have to learn the law by reading textbook, which is something more systematic. A lot of it is case law as opposed to legislation. Even in the common law jurisdiction, I don't think that we only have case law. We also have legislation, just like Hong Kong. We have case law, so we have lots of cases. We also have legislation, especially in criminal law. Legislation is more important than common law, but in civil law, it's just the opposite. In civil law, especially in contract law, in tort law, case law is more important than legislation. And then we go to the last one. The last one, or the last meaning of common law is in contrast with equity. So we have to leave it to the next lesson. That's lesson 3, because it's something quite complicated. We have to learn the development, the historical development of equity, and also we will use many examples to illustrate the different. Okay? So I will have to stop here. So for say slide 14 onward, so we have to, slide 13 onward, we have to leave it to the next lesson. That's lesson 3. Yeah, it was stopped in the break. Sorry. Very sorry. Now I think I have to. Please remind me. So if there's if you're doing the break, I'm so worried that there will be some disturbance. Very sorry. Okay. Starting from the break, the recording have been stopped. Oh, very sorry. So please tell me. Please tell me. Okay. So if there's anything wrong, okay. So next time, if there's anything wrong, so please tell me. Okay. The recording seems to have stopped. So very sorry. I just wonder whether I can do it. Say after the break. But I think. Sorry. Okay, so any more question? So if there's any question, please ask me question Now some technical mistake. I just want to know, I think I will discuss with TA to see whether I can do some remedial measure, whether I can do some recording, maybe after the break. I think during the break it should be chapter 3, chapter 2. So for after the break it should be chapter 3. Maybe I can do some recording, don't worry. So I can do some recording. So I think it's not too difficult. Don't worry. I can do some recording maybe tomorrow. So usually I do for the PowerPoint I can do the recording quite easy. So don't worry, I will do it tomorrow. So I can use the PowerPoint to do the recording. So Hilda asked me, recent cases more influential than the older one. You are correct. Because some old case, they may have already been overruled, so usually I will prefer the new case. But in teaching, we will start from the old case. Just like whatsoever discipline. Okay, usually the teacher will tell you something in the past. For example, you want to know the political system of Hong Kong. Usually the teacher will not just tell you the current situation. They will tell you the historical development. But of course, new case will be more preferred. For example, we have a case in say 2000 and also a case in 1980. So usually we will prefer a 2000 case. And also, if we have a case from Hong Kong, a case from England, usually the local case is also preferred. A local case will be more relevant. Any more question? You can ask whatsoever question. If you cannot think of any question, you may do it by email. I try my very best to reply to you. For the answer, I will also give you a short look. So don't worry. This one. So after we have finished all the answer, after we have finished all the questions, I will post this file to show. So if you have missed the answer, it doesn't matter. Of course, I cannot give you the answer before I ask you the question. Usually in the class, so we have some class discussion. Okay. So before we have the class discussion, I think it will not be so convenient for me to give you answer. But after we have finished the first 3 chapters, I will give you this one. Is called the name of the file is answer to question for chapter 1 and chapter 3. So for example, this one is a question on chapter 1. Okay, chapter 1. Okay. So this one is question on chapter 2. This one. So then we have question on chapter 3. Don't worry. For other jurisdictions, so usually they are not so preferable. Transition, when will the person of other common law jurisdiction be referred? Usually only when we cannot find a relevant case in Hong Kong or England. So the first priority is Hong Kong cases. But Hong Kong cases, we only have very short history. We only have very a small number of cases. Sometimes you cannot find relevant case in Hong Kong. So the second preference is England. And then, for example, Canada or Australia, they are some the least priority. Or no, I think it would be very unusual for us to refer to case in India or South Africa. I think it's very uncommon. Very unusual. Constitutional examiner, JL means judicial review. Please open.司法覆核JL nowadays is a very hot term. When I was law student, not so many people have heard of this term. But nowadays you always know this term because some people are very active in taking judicial review action. Judicial review king is Mr. 梁國雄he's the expert in judicial review 我最出名嘅梁國雄議員so 鄺卓堅鄺個鄺郭卓堅個鄺卓堅郭卓堅so 長洲覆核王so and also we have the JL King in 長洲Mr. Kong do you need I think loaded I think at this stage no need to memorize too many things or some of course for some key concept like common law legislation of course you have to load but it will be too early for you to memorize the law at this stage try to explore the law try to understand the law. I think for my teaching I always emphasize on understanding because if you can understand something you can memorize those things more easily. So sometimes I talk with some top law student in Hong Kong U law faculty. They tell me that they did not quite understand the law. They just memorize the law. From time to time they just memorize the law. For those brilliant students, sometimes they simply cannot understand the law. But if you can understand the law, it will be easier for you to memorize the law. It's my teaching, I say, for a very long time. Okay, thank you very much. So if you cannot think of any question, I think it doesn't matter. If you have any question, just send me an email. Okay, it's martin.co@hongkonguspace.hku.hk. Okay, thank you very much for attending the class. Also, all of you are so active in class participation. So it's really enjoyable experience for me. Okay, so thank you very much. So see you next Tuesday. Okay, thank you.